welcome everybody to another incredible episode of Joey's Legacy Roundtable, where we sit down with our animal specialists panel and attorneys who will be answering questions about veterinary care and animal law. Now, before we begin, I just want to make everyone know that the views and opinions that are expressed on this podcast aren't necessarily those reflected by Joey's Legacy. They are of the own individual authors and creators, and we don't necessarily align with every single mention that is reflected just per official policy. So thank you for being kind and aware and courteous to everyone. And please be sure to comment, leave a question in the chat, and we will be sure to get to it. But to kick us off on this great episode, we have our wonderful host, Mr. Scott Fine, and our lovely attorney and director on Joey's Legacy Board of Directors, Anna Morrison-Ricordati. Hello.
Anna. How are
Hi.
you? Good.
Hi.
Thanks for being here. You know, we've got a lot of issues that we deal with at Joey's Legacy. Many of them are on the legal side, of course, and a lot of questions come in during the week from members about various topics. And I've got a number of topics that, you know, that I'd like to have you comment on. And I invite everyone to submit a question in the chat, and we will present it to Anna, and we will see what Anna has to say. You know, actually, the number one topic that I am actually faced with is an email from someone that says, you know, hey, Scott, can you read this over? I want to post this on Yelp or Google. What do you think? And of course, I always start out, I'm not an attorney, and I always end with, please consult an attorney for, you know, for your best advice. And I don't really address it directly. I just basically say, if you state irrefutable facts and pure opinion, that's probably a good approach. But again, contact an attorney. What would you say to someone that submits a review that includes language like the vet? I want to post this on Google. The vet killed my dog. He was absolutely sadistic. The place that he works at is like a slaughterhouse. That kind of language. What would you advise that person to do?
Well, you know, first I would advise them in every different state, you know, the laws differ, you know, according to the state. So it really depends on where you're at. So you got to check with an attorney in that state. But, you know, generally speaking, you know, just addressing the law of defamation, you really have to be careful, because even if it's all true, you could still get pulled into court on a defamation claim that you have to defend. And because it's you know, we have American rule, unless there's something so far afield, or if it's if you can claim anti-SLAPP, which is somewhat harder to do than it sounds, that a SLAPP is a strategic lawsuit against public participation, but it's limited more than people might think. But basically, you really have to stick to the facts of what happened. Like this, you know, at 8 o'clock, I went to the facility. 8:01, I was allowed in. You know, 8:05, you know, I was sitting in there. You know, those types of things that are facts that are provable, facts that, you know, hopefully irrefutable would be the best way. But there are some areas in defamation you want to be really careful about. And when I say defamation, that encompasses not just something written, but something said, anything that, you know, could be interpreted as harming, you know, the other party, their reputation, their interests. And it counts even for a business. So it's not just an individual. So, you know, if I said something bad about Scott, you know, and it wasn't true, he could come after me. And same thing if I said something bad about Joey's Legacy and it wasn't true, Joey's Legacy would have the standing to bring a suit for defamation. So when you're wanting to post those things, you got to kind of step back and breathe a little bit and say, well, hang on a minute. It's not necessarily something that's going to be protected, you know, for a civil lawsuit. And there are certain categories, and again, differs every state, got to check with the attorneys in that state. But when you say somebody, like if you say, oh God, Dr. X totally killed my dog, he's inept, he can't practice in this profession, he's terrible. That can be interpreted as someone, you know, saying that they are incompetent in their field. And usually those types of categories, you know, somebody can't practice, you know, is unable to practice in their field would be defamation per se. Why is that worse? Is because in a defamation claim, just a general defamation claim that doesn't infer one of those categories like STDs, or you committed a crime, or you're incapable of performing your profession, and there's some others there, you don't have to prove damages to prove that defamation occurred and that you were injured. You do have to prove damages in a defamation per quad, or another thing that isn't one of those special categories of per se. So you might want to say something, even if it's to warn other people, hey, don't go there. But you really have to stick to things that are either, purely your opinion. Like you can say, well, man, Anna Morrison-Ricordati, her voice is so horrible, it's like nails on the chalkboard. That's your opinion. It's okay. And probably opinion of a few others. So it's okay to say something like that. But it's not okay if it's directed at their profession, or if it's one of those categories of per se, or even if it's something untrue. And even if it's something that, if you couch it in my opinion, he's a terrible doctor, inept in his profession, that's not going to be enough to take it out of what might be considered defamation. You have to just be very, very, very careful. And it's often better to take those statements that you would have put online and actually submit them to the veterinary board, or somebody else who, I understand, and believe me, Scott and I could talk for probably hours about how we have problems with the veterinary boards. But if you're submitting a statement to like a disciplinary authority, just like if you are submitting a statement to the police, those statements are not going to be considered defamatory, provided they're made in good faith, and that you're looking to actually get either somebody to get justice for a crime, or to report a crime, or to, in the case of veterinarians, to report misconduct that may be something that the disciplinary board can actually address. So there, if you're saying all those things in a letter to the disciplinary board, that's usually considered protected speech, or if you're in a court of law and you're testifying and you say something that's inside the courtrooms, those are generally considered protected speech. Just when you're outside the courtroom, you got to be really careful what you say, and that counts even on the anonymous boards. And not to over talk this one, but there are ways for people to contact a Yelp provider, or a Google review. They can sue those providers to get your name. And so even though you think you're posting anonymously, it might not be anonymous. It may ultimately be something that you could be held accountable for. So really, if you're going to relay what happened to you, you want to do it, just irrefutable facts if you're going to do that. But you are entitled to your opinion. You can say, in my opinion, I did not like this place. Okay. If somebody wants to ask you, you still got to be a little careful, what you say. You can say, here's what happened to me. These are the facts that are, happened in my case, and you allow them to draw their own opinion from that. But you have to be careful, because it's not just really defamation that comes into play, but there's also false light. And I think that's why sometimes people will go to the courts instead of, going to Yelp or these other places where they could get sued, just because in the court, you're allowed to make that case. You're allowed to make those allegations. And so long as they're made in good faith, meaning that you believe them to be true, and you believe, the truth of the facts behind what you've set forth, then, even if it's wrong, it's not necessarily something that they can come after you for defamation. It's part of the pleadings. But yeah, false light is another area, people need to watch out for, because it's sort of like if you describe it in a way, like if you were to say something like, well, Anna, geez, she's got 100 cats, God, so it kind of implies like, oh, it must be kind of in a bad way. But then if you put it in the proper context of, well, she has 100 cats, but she also has a 100-room mansion in a shelter she built for all of them, which I wish were true. But neither of those is true. But if you were going to say, like, Lena's got 100 cats, and to imply that, well, okay, there's something wrong there. If in fact I had a 100-room mansion and it was really a shelter for all these cats, that would be a false light, type of. It could be, brought as a false light. So you have to be careful how you relay those facts, as well as making sure that they are indeed facts, not just your thought on whether this particular vet is incompetent or not. So
a lot of our cases, and most of the cases that we see, involve alleged deception.
Yeah.
On the part of the veterinarian, mostly in terms of altering records. And our veterinarians are clearly bound by whatever is in the written records as far as basing their opinion on whatever they read, and not necessarily anything that the victim tells them happened. And we see this more often, I don't want to say more often than not, but quite a bit, where the veterinarian has already scrubbed the records. It doesn't reflect accurately what happened. The victim will tell our veterinarian, hey, I was there, I saw it, I know it happened. The veterinarian says, I believe you, but I can only go by what's in the written records because I have to sign this letter. And if it ever goes to court and I'm questioned by the defense, I don't want to perjure myself. So it becomes a bit of a slippery slope. Is there any advice you could provide to our victims and to any of our veterinarians that might be listening in terms of what's the best way to handle this?
Yeah. And again, always say this applies to everything in here, but it varies by state. But just generally speaking, if the veterinary records will typically contain communications as well. So if you get the veterinary records and you see that there are errors in there, many times a client can send in a letter saying, I request that this be placed with my veterinary records. Here are the discrepancies I noted. And you can put, like here's the pages. This page, during our conversation, I have no recollection of you telling me that drug was not meant to be combined with another drug. And in fact, you told me specifically, you and the staff said this, this, and this. So the more detailed you can be and the more precise you can be sending it, not just by email, maybe by certified mail, also by any other means that that they're going to get that information. That's important. It's also really important, the ounce of prevention, pound of cure kind of thing. If every time you go to the vet, you just routinely ask for the records, and they're going to give you the invoice, because they're busy. They're like everybody else. They're always going to give you the invoice, and it's usually not, suspicious or, anything that would raise a flag. But you can just tell them that, you like to have the whole record of your animal with you at all times, because maybe you travel, you might go to another state. You might be there might be an emergency. It's not so easy to get the records transferred when it's past 8 o'clock at night. You're in Iowa and you're coming out of Chicago, and, you're going to wherever you can for an emergency vet service. But it's always good to have your animal's records. So even if they just give you the invoice, you can just ask them at checkout, hey, can you email me the records from today? Or can you print them out? Because usually, sadly, they don't always have it done, because what'll happen is the veterinarian will write down their notes and then transfer it later, which is another area I think is rife with problems, because a lot of that transferring gets manipulated. And this happens so many times that I've lost count of how many times this has happened. And that's why when you look at each state's, veterinary practice rules, they are required to give you a copy of the records. So the veterinarians, if you request it, it's usually in writing, but that's email, that's fine. And you say, I'd like you to send me, records, for Fluffy, and, I'd like all of the records, not just the invoice, the computer records, the handwritten notes, any boarding sheets, drug logs. Often they won't give you the drug logs, but we've found in more than one case where the drug logs have reflected something different than what's recorded on the other logs. So it's important that they match up. Like we had a case where there were discrepancies in the amounts of fentanyl, that was given. And fentanyl, as you know, it's very powerful, and a very small amount of difference can make a huge impact and, can kill animals. So you have to be, you want to be vigilant to that. Again, with the drug logs, they may not give them to you, but, you can ask. But it doesn't have to be confrontational. It can simply be just your matter of practice, your routine, that you say, okay, great, thank you for the invoice. I'd really like you to send me a copy of the records. And, that includes the test results and, everything they have written up in the computer. So you can check them over right then and see if there's something that's different, because you may read in the record, like let's say it's something important, like they gave you drugs to administer to your animal and maybe they're sedatives. And if your animal's already on a sedative and you're being given another sedative, and you asked them when you were there, hey, is this going to be a problem? And they said, yeah, no problem. But you see then in the record, like, do not combine with any other sedatives. Whoa, heads up. That's something that, you'll at least be able to prevent, something bad happening. But it's also just really important because, yeah, more often than not, we see records disappear. We see changes made, usually in the report, conversations that either never happened or are simply not there. So either way, it's a problem. So you want to make sure that, your client, and you can always send an email back once you get the records. You can say, hey, I saw that this conversation wasn't in here. I just want to make sure it's part of the records for the future. Again, doesn't have to be confrontational, but it's really important. And it becomes, even after the fact, even when you get the records and you're sending them out to review, or before you send them to review, you can say, hey, I noticed these discrepancies. I want this made part of the file. Can you please do that? Because, the veterinarians, they're being asked. So that's why they're so important, to Joey's Legacy, to all of this, because without a veterinarian's review, we can't really bring a case unless it's something very obvious, like amputation of the wrong leg, or just a clear the totally wrong amount of a drug or something like that, where it's obvious. But, and again, different states differ, but most of them, in a professional setting, you have to have a professional review the file. And you have to, they have to say that there was a dereliction of the professional duty, or a failure to exercise an ordinary degree of professional skill or learning by one rendering the professional services. So, that it results in injury, loss, or damage. So it's a breach of the standard of care. And but for that breach, your animal wouldn't have been hurt or killed. So for them to do that, the reason they look to business records and the veterinarian's own records is because most people think in businesses, and it's kind of something you would assume, that the business has no reason to alter the records, or that's what you would think. At the time, they're just a matter of course. Like you enter this, when you go to buy a shirt at the store, there's your record. Inventory went in, inventory went out. They don't really think too much about doctoring anything at the time. So, at the time, in most of the business records, they're supposed to be kept as they were at the time the events occurred. So it only becomes a problem later when people get sued. And, if you get those records, and you have those records right away, then they can't be altered later because you have the copies. And it's called spoliation of evidence. It's just a different word for basically destroying or altering evidence.
So that's a great segue into my next question. About a week after Joey died, I returned to the veterinary hospital and requested all the records because I knew what my plan was, and I would need those records to be part of the complaint that I filed. They printed the records, handed them to me, and I was out of there in 5 minutes. I reviewed the records. Everything appeared accurate, correct, no deviations from what really happened. And I submitted the records with my complaint to the Florida board.
Yeah.
A period of time later, the attorney that I hired called me and he said, I just got the records that the vet submitted to the state as a result of your complaint. And he said, you're not going to believe it is so far off of what you picked up. You won't believe it. So he sent them to me. I compared them. There's a number of differences on the accurate records. The vet told me that this lipoma, a small fatty tumor on Joey's tail, did not need to be removed, and they normally don't remove them unless the lipoma is in a location that compromises the dog's lifestyle. On the altered records, the vet told the board that he told me numerous times that the lipoma needed to be removed, and I refused because I didn't want to spend the money. Just all kinds of outrageous stuff. And here it is, right? I've got the evidence right here. Okay. Absolutely irrefutable evidence that they altered the records. I took both sets of records to the local, to the state attorney's office, which happened not to be far from where I said, okay, you got this and you got this. She said, well, that's civil fraud. You can sue the vet for fraud. I said, I want to know if it's criminal fraud. Can you prosecute this with criminal statutes? All kinds of hesitancy, reluctance. The answer ended up being no. And so my point of telling that story is keeping in the same vein of altering records. Should we be more, at least now, 5 years later, should we be more aggressive or assertive in terms of trying to prosecute these matters? I know we do it civilly. Our attorneys sue for misrepresentation and concealment and other civil torts. But what about criminal? I mean, is it worth trying, or what do you think?
I think probably anywhere other than Chicago, it might be worth trying. I don't know if you read the headlines here. We've had some issues with the prosecutions taking place here. Well, no, there's a lot of crime, human against human crime that are not being prosecuted. And so, or at least that's the opinion of many people. So it's even harder when you're dealing with, with our non-human companions, which are immensely important to us. But until it happens to somebody, in power in one of those offices, a lot of it's not going to change. I mean, we even have cases where there has been intentional acts of cruelty against animals. I mean, clear, like repeated cases that have gone through the civil court, and have come out, in favor of the plaintiff who brought the case. And yet the criminal side, they won't do it, or they just say, oh, we don't have enough evidence. It's like, but it doesn't make sense. It's you can tell that there is clearly a bias. They don't, a lot of prosecutors don't want to go after the animal crimes, but even when they do, it almost has to be raising to a level of, like, I would say cruelty or torture, other than, fraud, even though a lot of times you'll see them prosecuting fraud cases when it's a money issue. So if you can get a fraud case where money is involved, or there's something where, like we've seen it in some of the charitable frauds and things like that, where occasionally a state's attorney will take interest because they're like, oh, hey, here's a money issue. But even when we had, there was cases involving one of the rescues out here where they had a number of euthanasia technicians who they were certified to be euthanasia technicians, but they admitted, or at least I believe it's there was a consent order, it was brought up through the IDFPR. It was one of the very few cases that became public because there was actual action taken. This is IDFPR, not state's attorney, but there they were euthanizing animals without weighing them first, which is a problem, because if you don't weigh them first, you don't know if that's going to be enough. And if you don't give enough, that's a truly agonizing and horrible death. Yeah. And for them to say they were just eyeballing it without any records, that's not enough. But even that, even though it was something addressed with IDFPR, or the Department of Financial and Professional Regulation, I didn't see anything about criminal charges, although they clearly could have been brought under the Humane Care for Animals Act, for torture and cruelty. So it's a hard standard, I guess, to meet, to get the prosecutors to really take interest. Or maybe we just need better prosecutors, people that are more geared towards, wanting or understanding that the roots of violence come from, those who take action against the most innocent, or those who can't fight back. That's the real roots. People that hurt children and animals, there's something very, very wrong.
I know in Lee County, Florida, where I lived a good part of my life, the sheriff there, the current sheriff's been in power for a while, huge animal advocate, will literally, and he keeps his word, he will jail anyone that they find that has tortured a companion animal, and they do spend jail time 6 months to a year, even on a first offense, because the state attorney is basically on the same page as the sheriff. So they're willing to prosecute to the limit of the law. And so they have great success in Lee County. Just wish that was the case around the country.
Well, a lot of these positions are elected. So it's something that, if you kind of pay attention, you ask the questions when they're running for office, you'll get some answers. And there have been a number of like judges and, prosecutors and that have been very pro animal. And, honestly, whether you care about animals or not, it matters because, there's the FBI, the link, people that harm animals, are, there's a link there. I think it's a correlative study. So they found like every serial killer started with torturing and harming animals. Doesn't mean that every person who tortures and harms animals is going to end up a serial killer, but there's a correlation, looking backwards. So it's like a red flag. But as far as, like fraud, yeah, I think these should be criminal fraud because I think there's a public interest. If you look at the statutes, that are involved, it says that, you have to get a license for this. That's the public trust. I mean, that license is something that can be revoked. So you would think that there would be enough of an interest here. And we found there's been other cases too, with abusing drugs that were meant for the animals. So it's not just, the fraud against any individual clients. There's other frauds and other things going on in these offices that are often unregulated because there's like maybe one office or one department in a state that would, inspect or regulate. But a lot of the vet, at least in Illinois, like the vet offices aren't going to be inspected by the same places that govern other animal businesses because the veterinarians have a license with the state. So they go under IDFPR, but IDFPR doesn't do inspections, or at least not regularly, or what we've been told. The Illinois Department of Agriculture does that, but they don't do them for the vet offices. So it leads to all sorts of problems with boarding, which is another, issue. If you have an animal in boarding at a vet office, it doesn't necessarily mean they're going to be safer there. There's been a lot of issues that come up in that context. But as far as like the records, there was one other thing I wanted to add. Because of the transition to more computerized records, there are some avenues to check, or to be able to check for changes that were made after the fact. Because usually when you're in a lawsuit, you want to maybe ask like, what's the software provider? So you can find out what the lockouts are. So if they get locked out after 24 hours or 48 hours, or if they have to override to make a change, that's important because you may have to do, or you may, to prove your case, sadly, it would be expensive, like really expensive. But to do computer forensics and looking at, hiring someone to go in, look at that system, see what changes were done. And because there is always a trail. There's always a trail. No matter how good you are at changing the records, there's going to be a trail there. But I concur with Scott. Like we had a case where, and normally we don't get to see what's going on with the Department of Professional Regulation because they keep those secret. But for whatever reason, a judge allowed us to get some of the records in one of the cases. And we saw that what was sent into professional regulation was far different than what was produced in the case. And that was a huge, just big red flag, and often it was more information than what was produced in the civil case. And, you have to think like, wait a minute, I don't, you raise a lot of issues about who wrote those documents, prepared that, and for what reasons they were being prepared. And, that it does get very disturbing, when you look at, how if one person if they're the only person in control of the records and they're getting sued for it, yeah, I think there's probably a natural tendency for people to protect themselves or, to do whatever they shouldn't be doing. But those records, if they're completely in the hands of the veterinarian, your only defense really is to get those records as soon as you can, or every time you go to a vet.
Okay. So we just had this come up recently. It's relating to the laws about statute of limitations. In my experience, is most states, it's 2 years for veterinary malpractice, 1 year in a couple of states, and 3 years in 1 or 2 states. So what do you do in a situation where, well, let me preface that with this. Is it a fair statement that the important date is either the date of the incident or when the victim first found out that there was veterinary negligence, whichever is later? Is that correct?
Well, again, it varies. It varies for the case law in every state, but you can make an argument. I don't know if it'll be successful or not, but it usually comes up in the context of fraud. Like, fraudulent concealment, those types of things. Like if you didn't find out, like if there were actual steps taken to cover up what happened, then it's more likely than not that the court's going to take a look at that and say, hey, I think you didn't have a reason to know about this. But let's say you found out about it, a year, like you bring Fluffy to the next veterinarian. The next veterinarian finds out, like, yeah, this looks like whatever happened at that last veterinarian, that was bad. And then you wait, maybe the full 2 years to bring a lawsuit. You might not be able to bring it then, because if you knew at the time the vet, it looks at when you reasonably should have known. But also, it also might, depending on the state, depending on how the case law is interpreted, it might backdate. Like, so if you went to that other vet and you knew that like a month prior, Fluffy had been given these drugs, you might then be held to that prior date because you knew about it pretty early on. So it's a question. It's not a clear answer. So you'd have to check, the law under those circumstances in that particular state.
Well, this is highly unusual, very unique, and this is the first time in 5 years I've ever come across this. This particular situation applies to a victim in our group that sent records to many of our vets over the years, and they've all basically come up with the same conclusion. I don't see any malpractice here. The victim came back to me recently and said, do we have any new vets we can try? Now we're well beyond the 2-year statute. Okay.
Yeah.
The records were submitted and this vet says, I certainly wouldn't do that. Yeah, I would think that's practice below the standard of care. Now we're 3 to 4 years past the incident date, but this is when she first learned that we got a vet willing to write a letter. So, I mean, what would you do there?
I don't know. I would have to check the facts against some of the fraud cases, things like that. But also just sometimes it doesn't really matter I shouldn't say it like that. Sometimes if just because you went to the wrong experts and didn't find it didn't necessarily mean that you were doing anything wrong. So I mean, the court could potentially say you took diligent steps to try to find out, but it might not. It's very dependent on the state, the law that applies, and the circumstances. So even those circumstances may not be fine-tuned enough to be able to find a case on it. I mean, somebody could certainly bring it, and if they're told, sorry, you missed the statutory deadline, well, then they missed it. But those, they can at least then say what happened. They can factually say what happened. If they have a letter, they can factually say, I have a letter, that says there was a breach of the standard of care. It's just that it doesn't allow for a lot of, I shouldn't say compensation, but if you will, justice, in the courts. And that's the hard part, because those statutory deadlines, yeah, there are some exceptions for sure. And that's why the attorneys have to really look at, what exactly happened. But I'm trying to think of a case, offhand, where that occurred. And I don't have an example, but I will start, look it up and see what I could find about it. But unless it rises to a level of concealment, where they actively tried to hide what happened, it's a little harder to get those, extended, or if it's something that, a reasonable person should have or would have known, that's another question. But yeah, it's really hard sometimes to get those statutory deadlines pushed out. But yeah, I have found that with some of the experts in that, and it's hard because the standard isn't really what one particular expert would do versus another. It's really just what a group of experts, whatever that group would be, if they would more likely, pick, if there were 2 options available, A or B, and they were equally available to that and they equally could have resulted in, health or not, then they're not going to be held responsible for picking the wrong one. But if more vets would take A, they would say, look, based on these circumstances, yeah, the best practice is to go with A, and you should have gone with A, you went with B. Well, then there's malpractice, but it still falls under the negligence area. So it wasn't intentional. And that gets into a lot of problems, as far as proving that, it's something that somebody would not have known, especially if they were contacting the professionals in that. And it also makes the case harder because, all these other vets are saying, well, I didn't really see, but that brings me to the other point about experts is that if you have contacted an expert and, you're talking to them about, or not, you don't want to really talk to them much. You really just want to give them records because that's what they need to use. But if they say, I don't really see anything here, they're in most states, and again, check your state, they would be considered a consulting expert, and you don't have to divulge that to anybody. You can still continue to look. You just you want to be, careful when you talk to experts, because if you actually use that expert for trial, as your witness, then any of your communications with that expert, and again, differs by state, but at least here in Illinois, you have to reveal what they are. So all of the email correspondence, all of the, if you had phone calls, those are not necessarily protected. It's not like talking to the attorney where that's privileged confidential. It's not like that with the expert unless you're not using them. And you may ask, why do they make that distinction? Why have consulting versus regular experts or trial experts? It's because the courts want you to be able to reach out and find out if you have a case before you bring it. And so they allow you to go to someone to consult and allow that to be privileged and protected because they want to give you every option to find out if you should or should not bring this case. And they assume that if you're using a consulting expert and you don't use them, well, okay, maybe you found a different expert. They don't want to dissuade people from reaching out for help, to find out about their case. They don't want to punish somebody for doing that, even if they didn't find the expert that they wanted to use in the first try. But as far as the experts at trial, the reason they allow all that, so every email you send, every message you leave them, everything, that's all fair game if it's kept. The reason they do that is because they want to see if there's bias. And so if you contact that expert and you say, this SOB veterinarian did this, that, and that, you're riled up, the vet's going to get riled up there. They don't want that kind of bias. You don't want it either, because you don't want somebody influenced by passions. You want them to look right at the records. You want them to say, hey, do I see something here? And the reason they look to the records is because the records are what the vets produce. That's their own statements. If they put in their own record, if their own documentation of what they did, if that's wrong, well, then you've got what you need. If the veterinarian has to rely on what you said or what you interpreted, well, that makes for a far weaker case, and it's much harder. And that's why, they look at the records, because they're considered, prima facie, like, oh, okay, well, people normally wouldn't mess with, the records. There's no reason to do that on a day-to-day basis. But for whatever reason, I'm sorry, in the veterinary malpractice cases, we see more instances of doctoring than other cases. And I don't know why that is. I mean, I've checked with other people in the medical, the human medical, and I don't even think they see it as much, as we see it. And, sometimes it's a big issue. More often than not, it's conversations that are not recorded properly. And that could be a result of the veterinarians writing it down and transferring it wrong, or it could be intentional. We don't know. We just know it's not what the people remember. And it's not what the people had in their own notes. And sometimes it's not even the same in the discharge papers, as it's in the records. So that's a key important difference. So save all the paperwork for sure. But yeah.
So take a case like a large conglomerate that swoops down and takes over a small animal practice, which has been commonplace in the last several years. If you would talk about that a little bit, also talk about if the differences, if there are any, between suing the conglomerate versus suing the small practice, which is easier.
Yeah, I think the small practice is usually, I would say, easier because the veterinarians tend to care more about their practice. They care about their reputation. And I shouldn't speak for all, because we've had some veterinarians that were absolutely not what you would expect, that were not so, in my humble opinion, so great. And I had expected the smaller practitioners to be better, but usually it's a little easier to sue the small practitioner because they have their own insurance. It's usually one of the big names, but they've gotten their own insurance. They work with their insurance company. They have their clients probably for a long time, and they do care about their position in the community, their reputation, and the work that they're doing. And if it was a mistake, albeit an honest one, they usually will step up and take responsibility, or they'll at least in many instances will do that. And if not, they get sued, and you find out that they probably should have retired 10 years ago or something like that.
Yeah.
So I mean, you have some, definitely opposite, goals there, but or I shouldn't say goals, opposite, ends there. But usually if they're independent, they have their insurance probably through PLIT or through, AVMA. And usually that insurance company will then hire a law firm. The law firm will represent the defendant. They'll look at the records, and they'll try to, figure out if it's something they should settle, or if it's something they're bent on going to court, about. And sometimes it's not in the hands of the attorney, and most of the time it's not. It's usually the insurance company making a decision as to whether they want to give that money out, or if they want to defend, if they want to just push it forward. But also the defendant, him or herself, to make that decision, because the insurance company may want to settle and a defendant may say no. They do have rights depending on their contracts. But suing the conglomerate, which is, it's funny, I was just reading right before we started this, the article. It's by Dr. Eric Johnson, a veterinarian. It's online. If you look it up, it's the takeover of veterinary practices by non-veterinary owners who are motivated chiefly or solely by profit. So it's an article from October 2019. It's a good article, because it does sum up kind of what we've been hitting recently with some of the big chains of veterinarian offices. And that has been happening in every state. So it's not just Illinois, it's not just Washington or California. It's there are a lot of issues coming up, because as the veterinarians are kind of practicing out or retiring, rather than finding someone, a new veterinarian to take over the practice, or coach, bringing someone in, an intern to teach them how they've done business. The trend has been for these big companies, chains, to come in and buy it, and then they'll use the name for a little while. And it's a little hard to follow. If you look up the corporations, you got to follow what name is what, and they're not usually registered in your state. They're registered somewhere else, but then they have a license to do business in the state. And so finding out even who to sue is kind of a problem at first, at least. And then, you sue them and you find out like, oh, well, they have their own way of dealing with it. So it may not be like an insurance, like that your typical insurance provider. It may be their own in-house people that are going to decide to deal with it. And it can be, we had one that was, actually two of the same three that were particularly difficult, because the attorneys, they had thousands of cases. I mean, not just this case, all sorts of other cases from the conglomerates that, not just veterinary malpractice, but other things where they basically were that insurance company, the arm of that insurance company. And it was a company that, either was, if not owned by, or, had some very close ties, to whatever business, was, the corporation or the handling agency, their close ties, so they basically were, if you will, like in-house insurance. So they weren't paid by case. They were paid, just their flat salaries, and this is all their cases of thousands and thousands. So they just wouldn't respond. So it was kind of like, beating against a rock. You'd go to court, you'd say, hey, I really need to get this discovery. Yeah. Yeah, we'll get it. And then months go by, still no discovery. We had to go back at least 4 times on one case, which is highly unusual. But it just, you end up, just hitting a wall, because they don't want to give out any money. They have no incentive to do it, because their veterinarians are probably going to work somewhere else. I mean, so oftentimes by the time we actually get to trial or near trial time, the veterinarians are gone to other practices. They're working from a different, corporate conglomerate, so it is more difficult. Sometimes it's a little easier to find documents, though, because the documentation is, they have their internal review process, and sometimes you get documents from the internal review that says, hey, fell below the standards of this company, and it's like, oh, okay, I'll take that. But it's just, it's very odd, how they have their own systems, and you would think sometimes that there might be some positive with the corporatization, if you will, that they have systems in place, they have procedures. But in reality, what I guess, what some of the feedback has been is that the rewards system is is not so beneficial to the individual veterinarians. And it, in some cases, has, at least in the articles, has pitted the veterinary clients, against, the veterinarian, because like they may have to meet a quota, or they may be expected to meet a certain number of procedures. And again, these are all from articles. I don't have personal knowledge of any of this. It's just, things that we've read, about veterinarians talking in articles about what they do or don't like, about the corporatization. So it may have, better salaries for the vets, at least initially. I think the expectations are a bit higher as to, churning, getting the clients in and out, and making sure that the procedures are, in-house, if at all possible. And that's a big problem when it comes to things like dental work, things that, you may have an older animal, and, you might not want to bring, Fluffy Senior to your local vet, for the veterinary cleaning and that, because if they go in and find a tooth that needs extraction, you may well need a specialist or somebody who really knows what they're doing to take that, tooth out, because they can break the jaw. They can do, animals have died in these surgeries because the person was a general practitioner doing dentistry. Maybe, maybe they knew the basics, but nowhere near qualified to do what they had to do for that particular animal. And that's why, if you're doing dental, look for a specialist, because they really, the difference in how many jaw breaks you see from a general practitioner versus specialist is dramatic. And that's not me talking. That's a PLIT article. That's an article that was written by the insurance people themselves, about watch out for this stuff, which is another source of information none of us really get, because we're not veterinarians. We don't subscribe to that insurance, so we don't know what they're sending out warnings about. But I guarantee you these articles exist, because we have some of them.
Yeah. So you mentioned how emails and phone calls, they have access to that, or they can't access that. And they, the veterinaries have their own medical record of what happened. If I am a companion parent taking my own version, my own records of what's going down to have on the side, what it would be more legally honored? Like, what is something that I could do as a pet parent to have a little bit more, honor legal backing in a court if it should come to that?
I think if you're asking for the records, like if you're talking about, emailing to request the records each time you see, usually the email is enough, because it's something you can track, like you'll have a copy, they'll have a copy. Usually there's a delivery confirmation, a receipt, those types of things are there. So a lot of times people used to, send in, certified delivery, return receipt requested. But honestly, most times now people just ignore certified mail, or they'll take it if they're at the business, but it's, and I've had so many of these little green cards, like I got like over here, like these little green cards that we're still required to send it out. It says, and it actually says COVID on there, so you don't even have a signature of anybody who received it. So so email is usually a good way. I know, like for the youngsters, probably like Colleen, like you prefer text messages to emails, but emails work pretty well, because like you do get the information, and then there's a electronic tracking. You can say, here's where it came in, this is from them. And I have cases, even not just veterinary malpractice cases, but cases involving companion animals where veterinarians have changed the records after the fact, because it was like an unmarried couple that split up, and they're disputing who owns the dog. So one person takes off with the dog, calls the vet hospital, says, hey, I'm the only owner now, take the other person off. And they're like, what? They find out, when you do subpoenas for these cases, that they were taken off. So veterinarians, like, they kind of get themselves into all sorts of trouble when they start messing with the records. But it does happen, and it's happened in, I think, of those, the custody cases, like 3, 4 so far where the vets have done that. But I will still say the worst one was the veterinarian who removed a microchip from a stolen cat. That was that one. I'm still kind of shaking my head about that.
And they lied about it on the record?
Apparently, like the person, their allegation, this is a current case, so I can't really talk too much about it, but I will say that, just generally speaking, when an animal is microchipped, the sole purpose of a microchip is to track the registered owner. And yes, ownership can change over time. Somebody could die, they could will their animal to someone else, but you still want to check that chip, just to make sure.
Right.
And usually you don't remove a chip unless there's some kind of medical condition, like if there was a carcinoma that developed, or if it were interfering with some kind of internal functioning. But if you're just taking it out to take it out, it doesn't really make sense. I mean, there are always people that'll argue that, oh, maybe there's something that would cause cancer, but it's more likely that the surgery itself would be more harmful than just leaving the chip there. But just like removing it without even checking to see who's on the chip, who's registered, kind of just sort of boggling. And then, the defense of like, well, I don't have to, I'm not required to do that. It's like, really? Like, really? Because like, yeah, there's a whole, I'm sure there could be entire series on the Veterinary Practice Act in every state and what they consider ownership and client. But I think the way some vets have interpreted it is the client, like whoever's paying me is the owner. But you can't really do that with animals, because it's sort of like if I took my car in and, I said, hey, while you're in there changing the oil, can you just scrape off the VIN number for me? Because I'll pay you to do it. Just do it.
Oh my God.
But that's what it feels like, and so it's just a very odd scenario. Like when a vet did that, and they actually got paid a lot to do it. Because like a chip itself costs like $25, but removing it was $1,000. So you got to wonder, what the incentives are in doing a surgery that's not medically necessary, and not checking the chip at all. I mean, you could just check and even say, hey, somebody's registered here that's not you. Can you explain it? Just check. Just makes sense. Just like I can bet you the mechanic or the guy, I brought the car into would say, no, I'm not going to scrape the VIN number off, It's like, so you just you gotta wonder.
Yeah, for sure. My goodness. Well, I have a question from the chat to take us a little back to the beginning, but is there a time limit? I know it varies from state to state, but is there a time limit for filing a complaint for vet malpractice in Chicago?
Well, there definitely is, and it's usually it's not even specific to vet malpractice, it's professional malpractice. And generally speaking, like I said, there's all sorts of caveats. So that's why you have to check your specific situation, with your state, with your area, but it's usually 2 years, or I should say here, there's again, caveats. So you always check, but the reason we recommend you bring them sooner than later is because it's not because of the statute, it's because people move. I mean, I've had cases where vets have moved out of the entire country. So it's harder to find things like in the cases I've had, like from the time I filed suit to the time that we actually, got to settle or to another place where the case was, resolvable, it had already changed ownership. So it was no longer the same clinic as before. And that gets into all sorts of mergers and acquisitions kind of things. But to the extent that it's not even the same people they're running the show, makes it very hard to find witnesses. So the sooner you bring your case, probably the better. At the very least, issuing like litigation hold letters, things that says preserve all the information. But oftentimes, it's better for people to just ask because they're allowed to ask in most states. I would say, check them all, but I'm sure that I would be surprised if there was a state that didn't allow the animal's owner to access those records. If you're the owner or client, however they define you, you're the one that paid for it, you can get the records for sure. And, if they didn't give them to you, that would be a shock. And if you, if you get those, you don't have to tell them, hey, I'm going to sue you, I want the records. You just have to say, I want the records, or just be in the custom and practice of getting them every time, because it's good practice to have them available in case of emergency.
That's great. Thank you.
So on the subject of general practitioners versus specialists.
Yeah.
So we've been doing this over 5 years. We've helped hundreds of people. Hundreds of letters have been written, certificates of merit, as they're called, citing breach of standard of care. Pretty much all of them proceeded through the settlement process and a few litigation successfully when the general practitioner, our vet, reviewed the work of a specialist, neurologist, cardiologist. Nothing was ever contested except for one time. One time the defense came back and said, hey, your vet is a general practitioner. What is, I forget it was who it was, but he or she, what does he or she know about cardiology? Who is the defendant? What do they know about cardiology? Ultimately, the case was settled by the defense, albeit at a much lower settlement amount. Of course, they cited the fact that the opinion of the general practitioner wasn't of the same quality as the opinion of another cardiologist, let's say, or neurologist, whatever the specialty was. But they did end up settling the case. We've only been called out one time on that. Do you find that's, do you run into that a lot? And how does it normally work outside of what we have experienced?
Well, I mean, generally, if you have a case of like, you're looking at a specialist who's doing something, and I'm not talking about a general practitioner, like a dentist doing something that a specialist should do, because they're a general practitioner can compare to a general practitioner. But if you're looking at a specialist, like a cardiologist, you really need to have another cardiologist review it, because it's someone of skill in the art. It's just like if somebody asked me to review a file of a tax attorney. I don't know how to do that.
Right.
I'm not going to know where they breached, if they breached at all.
Right.
So it's even within a particular, like if I looked at it and I saw that there were also, if I were reviewing another general practitioner's work on a tax case or a regular case, and I saw there were all these tax issues, I'm like, whoa, I don't think this guy had enough. He didn't have the knowledge to do this kind of case. That's where you would get, you would say a general practitioner could compare another general practitioner. But if it's a cardiologist, it's got to be another cardiologist, because they're those of the level of skill. They're the same level of skill that can say, but for this person, person's actions and their expected or anticipated level of knowledge. Because when you go to a specialist, who's a cardiologist, you're expecting them to know a lot about the heart. And you're not, when you go to a general practitioner, you're expecting them to know it's there, it functions, the basics, but you're not going to hold them to the level of knowledge that a cardiologist would be. It's like when you go to the dentist, you don't expect them to do brain surgery. So that kind of thing. So it's just like, it is important, and you want to catch that at the outset. And a lot of times, people are, very well-meaning, when they look at it. And there are times I could look at a case, that, like, oh, wow, I'm pretty sure, it may be maritime law, but I bet there was an error here, but it's still something that if I don't work in maritime law, I really shouldn't be reviewing that case, for breaches. So yeah, it's super important. And an expert can be disqualified if they don't have the right skills. And that's why you gotta watch, because every state will differ on how they qualify experts. It's established in statutes and case law and all these other areas. And you want to do your best to find an expert. It doesn't mean the expert has to be in the same state, or something like that. They just have to, or at least not in the case law that we've seen and in the cases that we've handled. But it definitely means that they have to have that same level of skill. And they have to be able to say, on a general level, not something specific to a particular space, but a general level, this person breached the standard of care, and but for that breach, the animal would not have been injured, or killed. But yeah, it does come up a lot. And so it's really important. And, again, the veterinarians who review that, I guess it's not as hard now. I've noticed that there are more veterinarians who are willing to step up. And that's a difference in the last 5 years. So that's it's a rapid change. And I have seen more of the specialists willing to step up, because they're seeing things that are going wrong in the general practitioner environment, saying like, look, if you can't do this, send it out. Don't try to wing it. Don't take that risk. Or if you do take that risk, make sure you tell the people, hey, I've only done maybe 2 of these. I've only done 1 of these. But like, if it's something that's outside of your expertise or your abilities, don't do it. Like, just don't. Trust me, if you walk into my office with a tax case, I will tell you no.
Go away. Right. And that makes perfect sense. Fortunately, now we've evolved.
Yeah, it has gotten better.
We have, it's gotten a lot better. Plus, we now have some of our veterinarians that review have extensive experience or are boarded in different areas of specialty. So we're now much better equipped to handle cases involving a specialist. So
but there is that, and I actually have testimony from people in depositions that say, like, well, would you ever testify against a veterinarian you found to breach the standard of care? No, because they actually, one of them actually admitted, like, yeah, it's a very amiable environment. We don't want to do that. We don't want to call people out. It's, it just,
nothing will change.
Yeah, in that scenario, it won't. But I see there has been, changes. There are more people willing, and it's almost like they stepped up and realized, like, look, we've got to set the standards here, because people will distrust if there are not others willing to step forward. Because, like, in the human medical malpractice, or even attorney malpractice, you do not have to look far for an attorney who will testify against another attorney, or a human medical doctor who will testify against another. But that wasn't the way it was 40, 50 years ago. It was almost, or it was very difficult, at least from what I was told from the people who, work in personal injury, and those who, work in attorney malpractice. And it was much harder many years ago, but that, changed. And I think the veterinary practices will change also, because it only lifts up the profession if others in the profession are willing to hold them to the standards that apply.
We now have our first attorney who practiced med mal for years, and
nice.
For years. He said, you know what, I want to get into this. It's basically, there's some variances, but basically the same kind of law, personal injury. So we're real excited to have him. And so things are definitely evolving, and we're real happy to be a big part of it.
I think it's going to be awesome. And I think the damages will get up, and it's not that the attorneys or anybody involved is like, oh, money hungry, gosh, can't wait to go after the vets. It's all about holding them accountable so that the standards are better. Exactly. And because the money people get in the cases like this, it's not life-changing kind of money. It's really just the sense of the need to hold accountable someone who hurt you and hurt that person, hurt that family deeply, and being told that you have no there's no avenue for justice only makes it worse, and that's why people will go to Yelp, and that's why people will go to these other areas and say things that could cause more damage, or and sometimes people, we talked a little bit about defamation. Sometimes a defamation suit is not brought because truth is a defense, and so that comes out. You crack open that lawsuit, you get an attorney who's just got a beat in them that day. They're going to dive in and find out what's really going on. And so sometimes people don't do defamation just because they don't want it all public record.
Yeah.
But that's where I think if you don't see as much on human malpractice or attorney malpractice on all these other places, is because there is a system. The justice system accounts for it, allows the appropriate damages, whereas it's not where it needs to be yet, for animals, for companions. And it needs to get there. If it doesn't, it's actually going to harm, I think, the veterinary profession more so than if they were to simply say, okay, insurance company, I demand that you guys cough up the amounts that are reasonable. And if you want me to pay $50 more or $100 more or whatever it is, I'll do it.
Of course. Absolutely. Cool.
Well, thank you so much, Anna, for joining us on Joey's Legacy Roundtable. You were so insightful, so wonderful. We appreciate you here at Joey's Legacy. Everyone who's worked with you and knows you boasts about you, and there's a reason for that. So we truly thank you for being here with us tonight and sharing your wonderful insights with us.
Super Thanks, kind of you guys. Very, very kind of you.
And we'll see you again in a couple of months, maybe. 6 weeks, whenever. Yeah.
And I definitely, come count me. I'll be in the audience for the vet mail attorney because I'm excited. I want to get some pointers too.
I gotta get him to come on.
You will.
He probably will. He probably will. Okay.
Awesome. Thank you everyone for joining, and have a wonderful rest of your evening.
Bye-bye. Take care.
Bye-bye.
Thanks, Anna. Bye-bye.
Bye.